Okay, so we could begin. So welcome to tonight's tutorial. We will be covering the topic on trade, commerce, and industrial relations, which is a specific dimension of the federal and state relations where there's been a lot of conflict. And a lot of jurisprudence is actually available in relation to this particular topic. Now, before we start talking about this specific topic, would there be any questions that you might have or anything you'd like to clarify before we proceed? I've actually muted everyone, so if you needed to say something, you're going to have to unmute yourself. And as a reminder, you will only gain points for the tutorial if you actually orally participate in these tutorials. So mere attendance or even just putting your remarks in the chat box will count for the online group discussion. So any comments, questions? Okay, so I guess none. So tonight, in terms of the key outcomes, after studying this topic, you should be able to discuss and explain the power of the Commonwealth to regulate trade and commerce among the states under Section 51(1) of the Constitution and the meaning of the freedom of trade, commerce, and intercourse among the states guaranteed by Section 92 of the Constitution. You should also be able to discuss and explain the scope and limits of Commonwealth power to make laws with respect to foreign and interstate trade, make laws with respect to foreign corporations and trading and finance corporations, and to regulate labor markets. So let's begin. Discussion question 1. In order to strengthen Australia's dairy industry, the Commonwealth Parliament passed the, passed the Dairy Industry Standardization Law, Commonwealth, that set quality standards in the production of dairy products such as milk, butter, cheese, etc. To comply with the law, commercial entities in the dairy industry needed to buy costly machinery. This had the effect of squeezing out small businesses, especially in South Australia and Tasmania. Jim Blogg, a South Australian milk producer, failed to comply with the law and was ordered to desist from further engaging in dairy production. He seeks to challenge the legislation for being discriminatory against small traders in less economically developed states and for protecting the bigger dairy businesses in other states. Advise Blog on whether his legal challenge is likely to prosper. Do I have a volunteer who may wish to answer discussion question 1?
I'm happy to volunteer.
Janet, well done. Thank you. Yes, go ahead, please.
I believe that the law itself is valid. Mm-hmm. And the reason I believe that it is valid is that it's not discriminating against any one state or all states. It is a law that has at its heart to strengthen the dairy industry. Mm. So by doing so, that's just the short answer.
Okay.
Would you like me to expand or not? The first question I asked myself was the law valid? Mm. Was it valid or was it invalid? Was it unconstitutional?
Okay. But Jim Blogg is claiming that it is in fact discriminatory against small traders because it requires them to buy costly machinery. And therefore it violates the idea that there should be free trade. If there is free trade, then there shouldn't be any burden or any attempt to discriminate. Because otherwise that might run afoul against Section 92 of the Constitution. That seems to be the argument here.
Okay, I don't think it's discriminatory.
Mm-hmm. Okay.
Discriminatory would be if it was against one person, to me, or against a particular sector of society. whilst the effect may be, from his perspective, discriminatory, the overall effect of it is not discriminatory. It's asking them to comply with a certain law so that the dairy industry can have a particular standard set.
Okay. What if we accept the view that it does in fact discriminate against small traders? Because I can make the argument that it does discriminate against small traders, especially in the less economically developed states. I mean, you put yourselves in the shoe of a small trader with less access to capital, and they are now required to purchase costly machinery. So given this kind of legislation, the effect is it does favor big businesses. So let's assume, to just make it more specific, what if the law actually said that, if for the purpose of standardization in the dairy industry, it is required that every single business in the dairy industry will have to purchase an equipment, let's say in the value of $5 million.
That would be discriminatory.
You can quickly say that, how can small traders survive? How can they compete against big businesses?
Well, that would be discriminatory. The fact that he doesn't have that equipment and needs to purchase it is incidental to that, to my thinking.
So let me just clarify, because on the one hand you said it was discriminatory, and now you're saying, when I said that the amount is $5 million. So how do you reconcile those two positions?
It's discriminatory, but it's not specifically discriminatory against any one person or classes of persons by having a general application across the board. The individual circumstances, the effect of that law may, for the individual, appear to be and may indeed be discriminatory, but the law itself, to me, is not discriminatory.
Okay, hang on. I just got a call there. Sorry. Okay, thank you, Janet. Very good. The question I have, though, is that, and I've seen Brad Corby here posting something in the chat box, and I'll probably ask Brad to explain his answer. Is it the fact that a law seems to discriminate that would then invalidate the law as being contrary to Section 92? So therefore, if you can allege that a law seems to discriminate against certain businesses or discriminate against certain states, then because on the basis of that discrimination, or probably the special burden that is imposed, then necessarily the law has to be invalid as being contrary to Section 92. Is that how it is? I see an answer from B here. B, would you like to use your mic?
Okay, I think I thought you were going to ask Brad to expound on the using the same
you could
Castlemaine and TUI.
Yeah.
I think the law is valid because according to Castlemaine and TUI, the law must be necessary or appropriate to and adapted to a legitimate object which enhances the welfare of the community. The burden placed on interstate trade or on any one person is incidental. However, the burden placed should not be disproportionate to the achievement of the legitimate object. So, it might be all right if they were required to buy something that's $100, but a case could be made that if you want them to buy something that's $5 million, whether that is disproportionate to the object they want to achieve, and finally whether a reasonable non-discriminatory alternative is available in order to achieve the object that the regulations want to achieve. So these are the things to consider.
Very good, B. So we got that. So it's not sufficient for a law to be invalidated simply because it discriminates. Either it discriminates against small traders or it discriminates against states. If we follow the wording of the case of Cole versus Whitfield, it must be relevantly discriminatory or discriminatory of the protectionist kind. So the mere fact that the Commonwealth Parliament ends up discriminating against certain states or may end up discriminating against certain consumers or even certain traders is not per se a ground for the law to be unconstitutional. What is not permissible under the Constitution, according to Cole versus Whitfield, is that the legislation is relevantly discriminatory. That is, it must be discriminatory of the protectionist kind. So it attempts to protect certain industries or perhaps certain states. Now, more importantly, however, as pointed out correctly by B and as referred to already by Brad in the case of Castlemaine Toohey versus South Australia, there is also, in a sense, an examination of the measure to determine whether or not it seeks actually to achieve a social purpose, in the sense that it permits, for example, the promotion of the welfare of the people, or it actually seeks to protect the welfare of the people, or in a sense, it seeks to regulate the industry. If it does, then so a law that may in fact impose a burden and may in a sense be protectionist can still be valid. And as pointed out by B, having said that, it is also crucial actually to determine whether or not the measures that are part of the legislation are reasonably connected or reasonably proportionate to the goals that are being sought to be achieved. So in other words, it is not enough that you can claim that it is a regulation, or it is not enough for you to say that it promotes the welfare of the people in general. There is a balancing in the sense that you need to determine whether or not the measures that are part of the legislation are reasonably proportionate or even reasonably necessary to the achievement of the goals. In other words, if there is some other means by which the same goals as set up by the Commonwealth Parliament could be achieved without coming up with very restrictive practices, then that which is non-restrictive would be preferred. Okay, clear? Now, however, before we in fact talk about the issue of whether or not this particular law is relevantly discriminatory and is of a protectionist kind, there is another issue that we need to deal with. So we're jumping the gun actually in a sense when we started talking about whether it is impermissible discrimination that we are dealing with. What is that other issue that we need to address here? So that's one crucial issue: the question of whether or not the law is relevantly discriminatory of a protectionist kind, meaning is it permissible or impermissible discrimination that is involved. But there is an equally important issue that we need to address first, and what is that?
The other one is whether the Commonwealth Parliament can pass a law with regards to this subject, so that, can you link it to a head of power under which it can validly pass this law?
Very good. So that is the first thing you always need to establish. So every time you're dealing with a Commonwealth parliamentary legislation, the question you always ask is whether or not the Commonwealth Parliament has the power to legislate on that subject matter. And the way to do that is to, at the very least, look at Section 51, if there could be a head of power on which the Commonwealth Parliament can base its power to legislate on that subject. Because in the absence of a head of power to which it could claim its legislative power, then then it would be unconstitutional for the Commonwealth Parliament to legislate in that regard, because as we remember, the power of the Commonwealth Parliament to legislate is restricted to that which is either expressly or implicitly provided for in the Australian Commonwealth Constitution, because everything else belongs to the states. And so therefore the question in relation to the dairy industry, we wonder, isn't a legislation in regard to the dairy industry something that only states can legislate on? Okay. Now, so Anthony, what do you think? Expounding and elaborating on what B has said, is there a head of power on which the Commonwealth Parliament can base its legislation? Or it could be anyone else. So is there a head of power which could be cited by the Commonwealth Parliament to legislate in relation to the dairy industry? Because there is nothing, obviously, in the Commonwealth Constitution, nothing in Section 51, that grants to the Commonwealth Parliament the power to legislate in relation to the dairy industry. So what do you think? So in other words, in the first place, if the Commonwealth Parliament cannot legislate on this subject matter, the question of whether or not the legislation is relevantly discriminatory is actually moot and academic, because it will be shut down at the very first instance. So, what do you think? I would have thought that only state parliaments could legislate in relation to the dairy industry. Okay, I see something from B, but I don't think that addresses the question I asked. Okay, you put it under Section 51(1) under corporations. Is that it? Is 51(1) about corporations? Or not? Okay, for Anthony, his mic isn't working. Okay, what do you think? How about the others? What can they say?
Manjo, it's Sarah.
Sarah, yes.
I tend to agree with B, and I thought that if you, as we were speaking last week, if you apply the engineer's case and look at it broadly, I guess you could maybe make a connection that it was some kind of trade, potentially, if you're really trying hard enough.
That's right. That's exactly what I'm waiting for. Yes, you can argue either on the basis of Section 51(1), which concerns interstate commerce, or arguably it's even international trade and commerce, because it could be argued that the purpose of the dairy industry standardization law is to help Australia's exports. And secondly, you could argue that it can also be based on Section 51, subsection 20 of the Constitution concerning trading or financial corporations. Because obviously, the production of dairy products involves trade, because you obviously have to sell dairy products. So, and the rule seems to be, what's the rule again? So how can you, so where does the engineer's case fit in this discussion? So just to wrap this up, where does the engineer's case fit in this discussion? Okay.
Well,
so, yes. Yeah, who was that?
Sorry, Sarah.
Sarah, yes.
Well, you're basically looking if the Commonwealth can legislate on the dairy industry, and then you have to work out where the dairy industry could fit into the Section 51, and then the engineer's case comes in to try and broaden a subject in Section 51. So then we can argue that yes, potentially can, because it involves trade.
Very good. So that's the kind of argument we need to see. Well done. And as Kent Staines pointed out, as a result of the engineer's case, it expanded the powers of the Commonwealth Parliament to legislate practically on almost any subject, which is also cited by Janet as well as by Anthony. From Nicholas, would you produce milk with no intent to trade it? Indeed. Ah, okay. Okay, well done. Very good. So we could move on. Yes.
Nicholas put that on following what I'd said.
Oh.
The legislation is talking about the production of the dairy milk.
Sorry, was it?
Well, it's talking about the production of the dairy milk, not, there's no mention about the trade of it. Yes, that might be the ultimate ends to what we do, but the legislation is trying to set production standards.
Yes. Okay, so how about that argument? The legislation doesn't talk about trade. It only talks about production.
Correct.
So in that case, can you still argue that Section 51(1) can provide the constitutional basis for this legislation? As pointed out by Brad, it doesn't talk about trade. It only talks about production.
Well, I think if I can back up my point, I think if you're talking about a quality standard, that implies that somebody is going to consume that product, that would therefore need to be traded from the producer to the consumer.
Okay. So the answer here is that for as long as you can make a reasonable connection of this law to one of the heads of power, in this case, trade and commerce, either interstate or international, then it could be argued that there is a head of power on which the Commonwealth Parliament can actually legislate on this subject matter. No, so even though the law does not explicitly talk about production of dairy products, it is in fact difficult to imagine, as pointed out by Nicholas, that you talk about the production of dairy products without actually talking about trading dairy products. So when you say trade, you're actually talking either of selling it or marketing it. So that's part of trade and commerce. Now, whether or not it actually means an exchange of cash doesn't really matter for as long as there is trade involved. So a trade simply means that there is a transaction between individuals, between consumer and a seller. It could even be between businesses. That still is a trade. So you have got to be able to read the word trading broadly. And as we will see later on, that is in fact what we will attempt to do when we look at the case of, when we touch upon the case of the barley monopoly board versus New South Wales, where there was an attempt on the part of the High Court to actually talk about what does trading really mean. And we will see later on that the word trading, as pointed out by the High Court, should be interpreted broadly. But we're going to... Yes, Janet.
Sorry, I was going to say, wasn't there a Western Australian football club or something that also went to court? I can't remember whether it was in your notes or whether it was in the textbook, but that was where trade was also interpreted to be very broadly, and it didn't have to be the only or sole part of the reason for the club, but it had to be even a small part of the club, and that then put it under the heading of trade and thus the Constitution.
That's right. Well done. Thank you, Janet. So now if there is something here that you will notice that when you come up with an answer, you really need to argue. You really need to argue your case. So it's insufficient for you to just say that, according to Section 51(1) or according to the engineer's case. You need to be able to explain your answer and argue your case in order for you to end up with a conclusion that is most likely going to be correct. Okay, so moving on, discussion question 2. The Commonwealth Parliament passed the Dietary Supplements Regulatory Act Commonwealth in order to regulate the production, distribution, sale, and marketing of dietary supplements, many of which had exaggerated claims and no proven efficacy. XYZ Enterprises was penalized under the Act for failing to meet regulatory standards. However, the activities, operations, and products of XYZ Enterprises were legally compliant under New South Wales legislation. XYZ Enterprises seeks to challenge the Commonwealth legislation on the ground that it cannot be penalized for acts that are lawful under New South Wales law. Advise XYZ Enterprises on whether its legal challenge is likely to prosper. Volunteers? Can I get a volunteer?
Manjo, it's Sarah again.
Yes.
Would we start with a similar question as we did last time?
Mm-hmm.
Can the Commonwealth Parliament pass legislation on this subject matter?
Okay, yes.
Which I think would be yes, because as per the last question, they're trading. Yeah, so that's what I think. Anyway, that's just to start off. I haven't done the question.
The first question is, oh, sorry, what happened there? Okay, hang on. Okay, so the first question was, does the Commonwealth Parliament have the power to legislate on this subject? And the answer is yes. On the basis of which particular section, Sarah?
I think it's section 51(1).
Okay.
Subsection 1.
Anything else?
Trading commerce.
Would there be any other provision that you can cite in order to justify that there is a head of power on which the Commonwealth Parliament can base this legislation on? Anything else? What happened here? Wait. I think I'm getting a warning that this will end in 10 minutes. This was meant to be a paid account, so I think somebody forgot to pay for this one. Now, if this gets cut off, we just resume in about 2 or 3 minutes. But I'm surprised why this is happening. Scott Beatty also had the same problem. Okay.
Manjo, it says at the top of the Zoom that it's only a 40-minute meeting.
Yeah, but that's because Zoom now recognizes the CQ Law 3 license as a free account. It used to be a paid account. So something has happened. I'll inform Stephen about this because we've never had the same problem before. So if we get cut off, we're just going to resume. I'm just going to, we're going to use the same ID number that we just, take off from there. So going back to my question, was there any other head of power on which the Commonwealth Parliament can base its power to legislate on the subject? So section 51(2). Is that the one? Okay, from B. So that's about trading corporations as well. Okay, so we could actually cite section 51(1) and section 51(20) on trading or financial corporations. So we've dealt with that. So okay, thank you, Janet. I saw the correction there. So if it can be said that the Commonwealth Parliament can enact legislation on this subject matter because there is a head of power which it can cite, how do we deal with the argument of XYZ Enterprises that it cannot be penalized for acts that are lawful under a state law? How do we deal with that argument?
Janet, it's Rob here. Sorry, Manjo.
Yes.
Janet's already picked up on this one, so I don't want to steal her thunder. She just found the actual section 109 for me.
Yes.
If the Commonwealth already occupies the field in a legitimate area where they can legislate, then the state legislation will be invalid to the extent of the inconsistency.
Okay, and what's your basis for saying that, Robert?
I believe it was section 109. I was looking for it, but Janet beat me to it.
Very good. So if we look at section 109 of the Australian Constitution, in the event that there is a conflict between Commonwealth legislation and state legislation, and the assumption that the Commonwealth Parliament can in fact validly legislate on the subject, then the Commonwealth legislation will prevail. Okay, so it will prevail, and the state parliament will, the legislation of the state parliament in regard to that field will be displaced to the extent that it is inconsistent with the Commonwealth legislation. So we need to remember, we need to be very familiar as well, therefore, with section 109. Okay, now it's 6:33. I think it'll be best if I just end the session right now, and then we go back into Zoom in about 2 or 3 minutes, rather than getting cut off automatically by Zoom. So I'd rather I end this meeting, and then I'll go back to the same meeting in about 2 or 3 minutes. Okay, so I'm gonna end the meeting now because it's gonna end automatically in about 6 minutes, and then we'll resume in about 2 minutes. Okay, so bye for now, but we're gonna go back in a short while.